spring and fall, we have a workshop and we try to talk about various topics that are important to the clients. And tonight we're going to talk about probate. And so many of you have trusts, and the purpose, one of the purposes, is to avoid the probate process. But you may be named as a personal representative in somebody else's plan. Or maybe you end up doing something for somebody else that doesn't have a plan at all. So we thought this would be a helpful topic, even though maybe it doesn't directly relate to your own planning. It will be helpful for you in the long run and maybe your loved ones as well.
We're going to talk a little bit about the divisions of the probate court, or the superior court. So the superior court has a lot of different arms, so to speak. So there's the civil arm, which is where all civil lawsuits are heard, and there's a lot of civil judges. Then there's criminal, juvenile, family law, which is a big division with all the divorces and all that, tax court, and then finally probate and mental health. The area of law where Crystal and I practice when we're in court is almost always in the probate and mental health courts, where they have judges and commissioners that handle only those matters at that particular time. Now they do rotate judges and commissioners, so they might sit on a calendar for a couple of years. Just about the time they get good at what they're doing, they move on, which I think is a really inefficient system. So if you have a judge or a probate commissioner who's relatively new on the job, they're really learning as they go. And you, as the lawyer, probably do know a little bit more than they do because you've been doing it longer. Because they've been on family law, they've been on criminal, just the way the system works.
So the probate court jurisdiction here has the ability to deal with any sort of issues regarding minors that receive an inheritance or lack capacity. Also deals with incapacitated adult probates, including guardianships and conservatorships, trust administrations. So even though your trust is a private document and doesn't need the court's involvement every step of the way, the probate court does have jurisdiction to decide disputes, to give direction to a trustee or beneficiaries and that type of thing. So the probate court is where folks would go if they do have an issue with the trust administration. And then also deals with death probate or decedent estates. So we'll talk a little bit about minors and probate. Why would a minor need a probate? And we run into this a lot when we are doing funding of trusts for clients. So when we have a client that comes in for trust-based planning, we review the assets, and we'll often run into where clients have named children as contingent beneficiaries on assets. And that is a very dangerous thing to do because if a minor has received an inheritance, that money is going to be dealt with through the probate court system. So if the minor is recovered or entitled to possession of assets, so maybe they were in a personal, they had a personal injury judgment where they were in a car accident, maybe they were harmed in a medical malpractice case or something like that, those assets are going to be dealt with through the court system. Common examples, again, inheritance from an estate or trust, recovery of life insurance or other payable on death assets where the decedent left that minor child as a direct beneficiary. And then usually there is family that is appointed as a representative that is required to be appointed by the court to handle the funds, and that's called a conservator here in Arizona. A guardian is basically a role that deals with healthcare decisions for someone that is in the probate court system, whether as a minor or an adult. And the conservator deals with the money side of things. Sometimes that may be the same person, or it may be separate individuals on that as well. The role of the conservator, as I mentioned, really is the person who manages the money. They have the legal capacity to represent the interests of the minor with regards to anything to deal with assets. They are able to apply for and receive benefits on behalf of that minor child. And they're also able to invest the assets. And they're supposed to do that prudently, which means they should, if they don't know how to handle it, they need to be going to a qualified investment advisor to help them make sure that they're getting the proper investments in place for that minor beneficiary. There's some options on how to deal with the funds as the conservator. And one of them is to invest the funds with no power to withdraw without court approval. And this is the most common for minors. What this means is the accounts are restricted. The court says this money has to go into a restricted bank account or investment account, and typically the guardian or conservator will end up funding the child's education or room and board or other things that they need out of their own pocket, and then they have to go and ask for permission to get reimbursed for those things. And then another option is to have ongoing withdrawal authority as the conservator, but in that situation, a bond is going to be required, and there's annual accountings that are due, and those can be very costly, and they are ongoing. So that the accounting process has gotten quite a bit more difficult in the probate court system. You all may recall several years ago the editorials by Lori Roberts in the Arizona Republic. And because of some of those articles and things that went on, the reporting requirements and accountings have changed tremendously, and it does drive up the cost for probates dealing with minors or incapacitated adults. Once the minor child reaches the age of capacity, which by law is 18, that money gets turned over to them. No ifs, ands, or buts, pretty much. Now, if they have a special need, let's say that they have Down syndrome, or they have a bad car accident, a brain injury, or something like that, those accounts might be still restricted in some sort of a special needs trust that is created by the court for that beneficiary. But otherwise, let's just say that beneficiary was named as contingent on a life insurance policy, and they got $100,000, and that's been restricted and used for them during the time that their parents are deceased and that sort of thing. Whatever's left in that account when they turn 18, they get. And how many 18-year-olds do you know that are equipped to receive that kind of money? Whatever the amount is, whether it's $10,000 or $10 million, it doesn't really matter. It's free money to them, and it's probably going to be gone pretty quickly. And so we're always concerned about, is it too much too soon? And while every child is different, a lot of times it is going to be too much too soon, and we're not going to see that money be used properly for that beneficiary. So the guardianship for minors, again, is the part where we're talking about making the healthcare decisions for them, making, the guardian is the one that enrolls them in school, and deals with insurance, and does all of those types of things. That's necessary when the parents are deceased, a parent might be missing or incarcerated, or they might have just been deemed to be unfit because of various reasons, drug abuse, child abuse, other things like that. There are several different people who have priority or standing to serve as a guardian. And when a person is deceased, in wills that we do, we always put guardianship language if there are minor children that says where those individuals are going to go. And the court weighs very strongly that nomination. And if there's not a reason not to give it to, have the children go to that guardian that is nominated in the will, that's where they will go. The court always has the responsibility to look at what is in the best interest of the child. So there are other people who might have some priority. A person nominated by a minor child, 14 years or older, has some, the child might have some say-so in that as well, or any other interested person. So relatives generally have first priority, but it can become a concern if you have competing interests, grandparents in other states or something like that, maybe family members that don't get along, maybe they all want the child. And sometimes as well, there are people who look really great on paper, but the decedent may never in a million years want them to serve as the guardian. So it's really important that their will state who they want to be the guardian, and they have some language about who they don't as well. The minor guardian's powers, they have, again, the power to deal with any of the personal affairs, so enrolling in school, things like that, using the money towards the minor's needs, providing a place of residence, consenting to marriage. And I mentioned as well, insuring the minor. So whether it's health insurance, car insurance, all of those different things are things that the guardian for the minor would take care of as well. And the guardian for the minor would terminate the guardianship when the minor has passed away, if the minor has been adopted, maybe by the guardian themselves or by another individual, if the guardian resigns or they have passed away. Now, if that child is still under 18, in that scenario, a new guardian would be appointed for the minor child. If the minor gets married or has turned 18, the guardianship would terminate at that point in time. But again, the point is that the guardianships for children or in the conservatorship can be very costly, and it's important to have some sort of plan in place to avoid that process, because again, when they turn 18, they get the money, and it's not always going to be in their best interest to do that.
Divorced parents who have joint custody of the minors, can there be conflicting two wills, or?
Yes. Well, there will be, probably. I mean, people get divorced. They should each have a plan. This comes up a lot. So let's say we're representing the father in his estate plan, and he recognizes that the mother has guardianship rights as the parent, and so he's not going to do in his will, try to trump that person, but he may name a backup. So he should name a backup.
So you should name a backup for
Absolutely. The second scenario, which we see happening, is where he says, I don't want that, no good, to be the guardian, and he may have good reasons and he may not. We just tell the client the mother has parental rights, and you can't sever those parental rights in your will. Now, you can, in your will or by an extraneous document, explain why you don't believe that the other parent should be the guardian. And again, it may be something that the court would listen to someday, because the court ultimately has to determine who the guardian should be. And there's priorities, but they can pass over a priority if it's not in the best interest of the child. And that's about the best you could hope for if you're hoping that your ex isn't going to be the guardian. You don't want to leave money to the minor to begin with. So you would have created a trust to leave money to the minor, and you could name somebody else as the trustee. So the guardian may take care of your child, but somebody else manages your child's money. So you can avoid that problem arising. So there is one sort of underlying lesson to be learned here, which is that if you're creating your own estate plan, or if you have parents that are wanting to leave money to children or grandchildren or whatever, don't leave anything to a minor, because they don't have legal capacity. So it's going to have to go into a court conservatorship where somebody else has to apply to hold the money, and then when the minor's 18, they get it. So it's not a good plan. And that would mean don't name a minor as a life insurance beneficiary, an IRA beneficiary. Any of those is the equivalent, leaving money to a minor. And you're not creating a plan that's going to allow success. It's expensive to go through court, and then when the minor turns 18, there's no safeguards. So, okay, we're going to switch over now, and for most of the remainder of the discussion, we're going to talk about adults. And the first area that we're going to talk is what we call living probate. So, again, death probate is the more obvious. It either involves probating a will, or if there's no will, probating an estate, where again the person is called intestate. But the mental health calendar in the probate courts includes guardianships of the person or conservatorships for the assets of the person. So guardianship over the person would be for an incapacitated adult, and conservatorship would be to manage the assets and the property of the incapacitated adult. And the definition of capacity or of incapacity is important, because by statute, a court isn't going to appoint a guardian or a conservator unless the person is incapacitated. And that's the statutory definition right there. Now, the way that is generally proven to the court is the court has a form that is given to the mental health expert, and the mental health expert completes it, kind of walking through with check boxes and filling in blanks, because the court wants there to be a very uniform process so that they're not having to read different reports and the way different people might reach different conclusions. This is pretty basic. If this person is incapacitated, the doctor has to reach that conclusion. So at the hearing that you go to for a guardianship or conservatorship, the court initially has to make this finding. And it has to be supported by medical or psychological opinion, and it can be contested. So in a contested case, a person may contest that they're not incapacitated, and there could be other medical opinions as well. That's ultimately something that the court has to find. So we'll talk just briefly about guardians. So the reason that the guardians and the conservators are different and they're under different statutes is because the guardian generally doesn't have any control over property. They're only taking care of the person. So if you're the guardian of an adult person, these are some of the responsibilities that you have. Some of them are very basic, making sure that they're living safely and that they have medical care, and if they can be trained or educated, that they're getting education and getting all the medical care that they need. That's just, it's in a way you kind of are the parent, except you're the parent of an adult is what it amounts to. So how are the guardians appointed? So very similar. Let's say that you're married to somebody who's incapacitated, and while you're married, you're the caretaker. You can actually appoint in your own will a successor. So you could say, I appoint so-and-so to become the guardian of my spouse. And that's one way that the court would accept a nomination. You can be a guardian in another state, and the court, through a process here, will recognize that appointment. The ward, if the court finds has sufficient capacity, can nominate somebody to take care of him or her. So, and if you have a power of attorney, so if you've created a power of attorney for health or finance, and you become incapacitated, the persons that you've appointed would have another level of priority. So sometimes the courts have a number of people who they can, pick and choose through, and sometimes they don't. So here's some of the priorities by statute. I won't have to read those off to you. Usually it's either a family member or it's a private fiduciary. That last item there are lots of companies in town, and their only business is taking care of other people's money and taking care of other people, and they're called private fiduciaries. So here's the basics of the procedure. So anytime you believe that somebody's incapacitated, the first thing you need to do is you need to get that medical opinion. You won't get anywhere without it. So again, the court's form of medical opinion would support your petition. Then you file your petition, and you get a hearing with the court, and a few weeks later, you're in court. The court will appoint an attorney to represent what's now called the ward, or the proposed ward, and there's a social worker, generally, that the court will send out and interview you if you're the person filing the petition, wanting to see where the ward lives and make sure it's a safe environment. Those come back to the court in the form of reports, and at the hearing, the court reviews all that information. Once you're appointed, you get what are called letters issued by the clerk of court, and those letters basically are your authority. Those can be presented to hospitals, schools, insurance companies, letting those third parties know that you have legal and sometimes financial responsibility over a person. So with guardians only, there isn't a great amount of check and balance within the court system because there's no real money involved. So the accounting process that we've been talking about, that applies to conservatorships. If it's only a guardianship, you have to file an annual report, and the annual report lets the court know that everything is going okay, where the guardian and the ward are living, if there have been any changes in the ward's condition. And as long as things are going okay, that's about all you need to do. Now, if the court reads this and becomes alarmed and feels there's something going on that the court's not happy about, then you could be asked to come to court and explain what's going on. So when does a guardianship terminate? If the ward recovers from the incapacity, it will terminate. And the guardian would have to petition for termination and would have to prove that the ward is recovered. Or if the ward dies, which is generally more common, then the guardian files a notice of death, and that terminates the proceedings. So our next subject is adult conservatorships, which I'm assuming, are we ready to pass the baton?
No, we can't.
Okay.
and then you can evict it.
Okay, so out of conservatorships are going to be talking about money, basically.
So these things are going to be necessary again if a person is found to be incapacitated by reason of those things that are set forth in the statute. Maybe it is because they just can't handle their financial affairs for some reason or another. Maybe they have dementia, Alzheimer's, drug abuse issues, other things like that. And in those situations, it is really important that the court does appoint a conservator. And so anytime the incapacitated adult owns money or other property that requires some management or protection, that is when a conservator is going to get involved. So even if you think about this from the level of, if you have an adult child and they don't have any sort of planning at all and they're in a bad car accident or something of that nature, some sort of accident, if they have no plan in place, someone is going to need to be appointed as a conservator to pay their bills, to make decisions for them. And this probate court process is the one that does that. And the conservator is going to be handling the money and again, investing it in those things. Very similar to the guardianship for the procedure, physician's certificate of incapacity must be obtained, so there is investigation and medical expert information that's taken care of there. Filing the petition, you've got to disclose the nature of what is wrong with the ward, as well as the value of the assets and to be protected, whether they're life insurance, IRAs, 401ks, business interests. Sometimes we'll find that business owners don't have any sort of a plan either, and we want their business to be able to continue because that is how their family is supported. So a conservator will be appointed to do those sorts of things. There will be a court-appointed lawyer for the ward. The conservator will often also have their own lawyer. Then there's a hearing and there's notice to all the parties, including the ward. It's very important that the ward gets notice as well, just as in the guardianship. And then the hearing will occur. If the court finds that it is necessary, then they'll look to find out who has the priority. And very similar again to the guardianship provisions. Spouse, adult child, other individuals, they're typically a relative and will be appointed in that situation. But again, private fiduciaries are also great there, as well as corporate trustees on occasion because they have experience dealing with the money side of things. The court is typically going to require a bond because the individual is going to be dealing with the money. The court wants to make sure if they abscond with the money, there's going to be insurance, the bond to pay back the estate, to take care of that ward. So it's typically going to be determined by figuring out the value of the assets, looking at the estimated income for a year, very technical, minus the value of securities and restricted real estate. And then this is just an example of how that bond would be required or determined. And typically we reach out to the bond companies to help us determine those things as well. Is that correct, Lou, when it comes to that? Or do you specifically determine this by the formula?
Well, you have a choice. So in this example, if you have $1.5 million estate, it's expensive to pay for a bond for $1.5 million. So the court will allow you to narrow that amount down by agreeing that you don't really need $1.5 million to take care of the person. Typically, you're the guardian and the conservator. And so you might agree that you'll restrict, in this case, $800,000, so that you're agreeing that you won't access it without court approval. So that takes the amount of the bond down because you're not going to access that money. It's not at risk because the bank's going to have a restricted account set up for it. And then you might agree that you won't sell the real estate without court approval. So you don't need to bond the real estate. So you can get your bond down in a case like this to a much more affordable amount of $300,000. And then when you need court approval, so you say you run out of cash. So in this case, you put aside a couple $100,000, plus you're getting annual income. So if you run out of cash down the road, you just go back to the court and ask for permission to unrestrict some money. Or if you want to sell the real estate, you ask the court to allow you to sell the real estate. That way you keep your bond affordable. So it'd be you know, just unnecessary to have to go get $1.5 million bond when you don't need $1.5 million to operate the estate. Yeah.
Yes, Joyce?
How would that compare to if somebody has the powers of attorney established?
So typically with the powers of attorney, the financial power of attorney is going to lessen the need for a guardianship or a conservatorship. That is the goal when we do those in our practice and for any attorney that does powers of attorney. The financial powers of attorney are typically going to be durable so that they will survive any sort of incapacity situation. And it's going to have powers listed so that the agent under the power of attorney has the ability to buy and sell property and do other things without the need for a bond. What we find, what we have been finding more recently is that there are a number of financial institutions that will not accept powers of attorney if they're over a certain number of years old, because with the amount of elder abuse that goes on in this state as well as in others, financial institutions want to make sure that those things are still valid and that you know, that the person really does still want that individual to serve. And so we always do, like we mentioned, put some language in there that says that the agent under the power of attorney can be the conservator, but we still ask that they serve without bond, correct? Yeah, as many of you know, we have a maintenance program in our practice and where clients can come and visit with us every year, talk about things, get updated powers of attorney so that those things do not become an issue later on.
But we represent a credit union, a fairly recent client, and really the biggest concern they have and the reason that they wanted local counsel is that it happens a lot. People come in, they have a 5 or 6 year old power of attorney, and they want to withdraw all of mom's money. Boy, they can talk about, you know, putting the fear of God in you, because if that teller accepts that and it's a fraud or it doesn't have the right power language in it, that's just a big lawsuit waiting to happen. And that's just where we find most of the power of attorney power struggle is with institutions that they just feel very at risk.
There are financial reporting duties that the conservator has. It's the same type of thing for the minor children. So, but this is where it really gets complex. So there has to be an inventory of the assets within 90 days. And one of the changes that happened several years ago is that there also has to be a proposed budget filed. And it has to be filed within 90 days. And what makes that so hard is a lot of times within 90 days, that's not a lot of time to really even figure out what assets the ward had or what bills they have out there, and to try to get all of that done. But it becomes difficult, but it's a very important piece that must get done. There are also annual accountings that have to be reported to the court, and they're very detailed and complex. There are multiple pages, multiple spreadsheets. We've actually had some accountants that we've tried to have do them, and they couldn't even do them. So we do them in our office, but they are complex, and it becomes costly for the estate. They must be reviewed and approved by the court. Very often they get kicked back because there's an accounting office within the court division that reviews those, and you know they're kind of down in a basement and doing their own thing, and you can never talk to one of them, and they just keep kicking them back because this is off or that is off. And it will not be approved by the court until all of those things are actually approved and checked off by the accountants for the court division. The conservatorship will, again, terminate if the ward is no longer incapacitated or if the ward passes away. And upon that termination, the conservator is going to need to file the final accounting and is going to receive an order discharging the bond. Probate is really the process of administering the assets and passing them on to the rightful heirs, whether it's heirs under the intestate laws or heirs that are named in a will. In Arizona, we call the person who is appointed to actually do and administer the estate, we call that the personal representative here in Arizona. Many of you may remember it being called the executor, and in many other states that is what it is called. So when is a probate necessary, or what assets are subject to probate? So this is really important because any asset that is owned jointly with another person that has right of survivorship language on it, Anything that is payable on death to another person, maybe like a life insurance policy, annuities, IRAs, or even a beneficiary deed on a home, or titled in the name of the trust, the John and Mary Sample revocable trust. Anything that's titled in one of those ways or has a beneficiary is going to pass outside of the probate process. No need for probate on those assets. So what is it that is subject to probate? It's assets that are in the decedent's own name, without any joint owner, without any beneficiary. Or maybe they had a beneficiary, but it's their already deceased spouse. We run into that a lot of times as well. So really important that individuals keep an eye on how their beneficiaries are set up, how their assets are titled, because otherwise we're going to be subject to probate at that point in time. So those assets cannot be transferred without some sort of court-appointed personal representative having the power and the control over the estate. And we'll talk about in a few minutes about there are some small estate processes or procedures that mean that you don't have to go through a full-blown probate, but most of the time we're running into folks that need an actual probate in that situation. The personal representative has very, very broad powers. They can buy and sell assets. They can compromise the debt. They're typically not buying assets in this situation because they're trying to get things out of the estate in the end. They can abandon property of no value. Timeshares is a big one that we see a lot of. And many of our clients have timeshares and they pay a lot every year for maintenance fees. And maybe there aren't any beneficiaries who want those assets. They don't want to take on the maintenance fees. The personal representative has the authority to abandon that property and not to continue it. We have found as well that it's really hard to sell. A lot of times people think, well, we can sell this on the open market. But even if you want to give it to a charity, you typically have to pay to give it to the charity. You got to pay the maintenance fees ahead of time for that charity to even accept it. So timeshares are definitely one thing that we might abandon in a probate. Operating business, that, like I mentioned before, is very important, especially if the decedent is running a family business that is providing the assets for the rest of the family and the income there. And then the personal representative is also going to transfer those assets to the rightful successors. The personal representative has to determine who those rightful successors are. In a will, it's going to say typically who those beneficiaries are. But what happens if one of those beneficiaries is deceased already, right? So we want to look at the language of the will itself to see where the assets go. If there isn't a will and the decedent has died intestate, we look at the intestate statutes to see who the rightful heirs are. And sometimes maybe an heir is missing. Maybe there is a child that has been estranged and nobody knows where that person is. So there's a process, typically through the court and through the statutes, to wait it out for at least some time. You can hire companies to do heir searches, to try to find them, skip traces, all kinds of stuff, private detectives. But should the estate have to pay for all of those? But those are things the personal representative is going to be looking at.
Actually, two ways that what we call death probate, so we're distinguishing here the guardianships and the conservatorships and whatnot. Thank you. So we're distinguishing, there's too many things here. We're distinguishing between the different kind of probate proceedings. Now we definitely are into the death probate. So you can either file informally, which the vast majority of probate cases are filed informally, or formal, which is the other option. So what is informal? If you have a will, and the will is regular on its face, it's meaning it's valid and it's an original, then and the person who's filing it is either appointed in the will, which is most typical, or if the will, say that will names a personal representative who's deceased, so the next person in line, either in the will as an alternate, or by statute, which would be certain relatives like spouses and children and whatnot, can file, and that can all be filed without going to court. So what really informal means is the court has a position that's called a registrar, and the probate registrar receives informal probate packages every day and reviews them, and if everything, if all the boxes can be checked, the will can be admitted the personal representative appointed, and nobody has ever had to step into the courtroom to do that. And I would say that in our practice, easily 90% of probates are informal. So here's just, again, a few things. So sometimes where you may get into a situation where it's not really a complex estate, but there's no will, and you may have more than one person who has equal priority for appointment. So let's say that you're deceased and you have 3 children. Well, all 3 of your children have priority. So if one of them files to be appointed as the personal representative of your estate, but can't get the other 2 to agree and say, I give up my right and I'm willing to let so-and-so, then the court will not do that informally. So that's one of those situations where the court's going to require formal. So where we do have a case where we have multiple people of the same priority, we'll usually try to get those who aren't going to serve to sign a paper called a renunciation. And that's just required if you're going to go informal. And obviously the biggest advantage of informal is to save time and money. If you don't have to go to court, you're saving the whole process. The petitioner doesn't have to go to court, and the petitioner doesn't have to save the lawyer or pay the lawyer to go to court. It's faster because the informal probate can be sent down to the registrar, and within a few days we can have a personal representative appointed. Informal, we have to file a petition and get a hearing, and that can take weeks. So the formal probate seeks the admission of the will, and if no will, the appointment in a formal proceeding. So why is formal generally needed? So the most common in our practice is the original will can't be found. So a copy of the will has been found, and everybody thinks it's the last will, but they can't find the original. Can't go informal on that. You have to file a petition for formal probate, and you have to prove to the court that this is the last unrevoked will of this person. How do you do that? We do that sometimes through our practice because we're the ones that created the will, and we can at least attest that we've continued to represent this person, and to our knowledge, they've never created another will. Other ways could be other family members saying that they've never seen another will, they never heard of another will, this is the will they always saw. So usually we can prove that it's the last will. Again, if we have more than one person with priority, and we can't get everybody to agree, then we have to go formal. So what happens at a formal hearing? The court will, after swearing everybody in, want to know what's going on and want to hear if there's witnesses to prove that if it's a copy of the will, the court has to be satisfied that it is the last will and testament. And if anybody who has equal priority, we have to prove that they've been given notice, so they at least have the opportunity to be there, and they could come in and contest if they wanted to. We have to publish a notice in the newspaper. When all formal probates require that we publish in the little classified section of the newspaper that nobody reads, so that we can say that we've given official notice. So we have to mail the notice to known people, and then the rest of the world can read it in the newspaper. Once the court appoints the personal representative, which it could either happen informally or formally, then the procedure is generally the same. So even though you may have to open a case formally, you don't have to proceed formally all the way through. It's very rare, in fact, that you're ever going to get back into the courtroom after you've had a formal probate. The court has made the findings, appointed a personal representative, and then we have what are called letters issued by the clerk, and the letters are called letters testamentary, and they give the personal representative the power to represent the estate, do business for the estate, do all the things that Crystal was talking about, sell property, give away property, compromise debt, everything that needs to be done in the administration of an estate. We have to publish notice to creditors in the newspaper, and we have to give notice to known creditors. So we ask our client to bring a list in of credit card debts and doctor bills and anything that they think reasonably leads us to believe that there's money owed, because those creditors are entitled to notice to give the mail.
Calling from a
And then the last piece would be we mail notice to anybody who's interested, which typically would be any heir, any beneficiary, and they're given notice that they can come in and now contest proceedings. So lots of notices given, a lot of due process. So at the end of a probate proceeding, if you're not happy, and you would have had a chance to complain because you should have gotten plenty of notice. Creditor claims in probate. One of the obligations of the personal representative is to pay bills. Some of the bills are pretty obvious because they're credit card bills that have been coming in the mail, doctor bills that come in the mail. But we want there to be a formal process because getting a bill in the mail is not a formal presentation of a claim. And the personal representative is entitled to have creditors formalize and submit their claims, what's owed, why it's owed, and then the personal representative can act on that, which is either contest it or pay it. If the claim is filed and the personal representative doesn't contest it, we don't have to do anything. We can just pay it. But there's a window so that shortens the time frame so that probates don't have to go on forever. So there's a 4-month window after presentations of claims for the publication and the mailing of the notice, so that the creditors have a shorter time frame to submit their claims. What that does is it gives the personal representative the opportunity to administer the estate in a shorter window, usually a 4 to 6 month window. And it means that some claims are going to be ignored. If the creditor doesn't submit a claim, then you don't have to pay it. So we can cull out some creditor claims, because if the creditor doesn't pursue it, the personal representative has no obligation to go looking for it. Again, technically and legally, Visa sending a bill to you, even if you passed away, is not presentation of a claim.
Concerns though that we have, we usually talk to folks about not paying the claims necessarily right away, is because there are certain claims that have priority over others. So let's say there's a tax bill out there. The PR didn't know that the person hadn't been paying their taxes or filing their tax return. And that Visa bill comes in, and the personal representative pays that Visa bill and pays the hospital bills and whatever else, and there's no money left to pay the federal or the other taxes. That money is going to come right out of the personal representative's own pocket. They're personally liable for that. So it's really important that as a personal representative, you wait and don't just start paying all of those things. If the estate is known to be, is going to be a nice, very solvent estate, that's one thing. But we usually will request the clients wait to pay until that creditor period is run, so we know what other claims are out there still.
And truly, most probates don't involve, real huge claims. So paying credit card bills and things like that isn't going to bankrupt the estate. But if it's a small estate, or if there is a risk that there are some larger claims out there, then it's really important to have a more formal process and not just pay every bill that comes in. And to make sure that the creditor has formally presented their claim. But that's why it's so important to have a process, and if you're a personal representative, to not just kind of a knee-jerk reaction to pay every claim as they come in, because you just don't know what they're for, you don't know how much money you're going to have, and there's just no rush. I mean, creditors really can't force the issue.
The person nominated in the will does have priority to open that probate, but if none is opened, a creditor also has priority later on down the road. And if that creditor wants to pursue it because they don't believe that the estate is actually insolvent, they can open their own probate. They can force you into probate. It rarely happens. Wouldn't you say?
No, it definitely rarely happens. We've done it, but representing the creditor, because sometimes the creditor feels that it's the only way they're ever going to get paid if they kind of push the button and start the process. I mean, one of the reasons that you would file probate up front is that you may have assets that you can't administer without the need for probate, such as real estate, money in the bank. So the creditor issue isn't probably the reason you filed probate, but now that you're in there, you have a given amount of assets, you're going to need to negotiate with the creditors and try to figure out a way to pay them off. Because there are statute of limitations, so eventually, if enough time goes by, creditor can't sue anymore. Unfortunately, it's 6 years on a written debt, so that would be the longest statute, would be a written contract. So it would be a long wait, but the longer you wait, the more likely they're letting it go. So a lot of times they just make that decision that it's not worthwhile pursuing it.
We'll talk a little bit about the probate inventory. Just like in the guardianship and conservatorship arena, you do have to file an inventory. It's typically, or it's due within 90 days of the opening of the probate. The personal representative is to prepare that inventory and list of all of the assets and the values, and provide that to all the heirs and devisees. Now, that inventory can be filed with the court, but remember, probate is a public process, so there are people whose job it is to go look at the probate filings every day. And most of our clients don't want that information being known to the entire world. So our probate statutes do allow a private distribution of the inventory and appraisement to those heirs and devisees. That's typically the process that we use in our office. So there's a private mailing out to those individuals, and then we will file a proof of mailing with the court so that the court knows that that inventory has gone out. It's important just to list the items with reasonable detail, the market value. Typically determining the date of death value is important as well. And noting whether it's a community property asset or a separate property asset, because that again goes to if there are debts, whether they're community debts and separate debts, and how that's going to be distributed. And then there is a duty to supplement. So if you file that original inventory and you find out later that there are additional assets, or you thought the value was one thing and it's really something else, you can file an amended inventory and appraisement, and the personal representative does have a duty to do that. And then when we get to the time where it's ready to close, so that's typically, you cannot close before that 4-month creditor window, so it's typically going to be after that. Sometimes we'll have an estate that closes very close to that time frame, but many times it's going to be longer, maybe 6 months, 18 months, depending on if their tax returns need to be filed, how close are we to that income tax filing time. But once that is done, the probate can be closed informally by just filing a closing document with the probate court. And that statement really just says that all claims have been paid, all the money has been distributed, etc., and all the, that all the heirs and devisees have been given the notice and they've received the written accounting, that type of thing. And then I like to, and I think Lou does as well, have the beneficiaries or the heirs sign a receipt acknowledging that they've received the money and releasing the personal representative from any ongoing liability there as well. The personal representative can file and close formally, and occasionally we'll have the personal representative do that, especially if there's going to be some concern about who gets what asset. If we're proposing some, maybe not necessarily equal split of assets, but something that might throw concern with the beneficiaries, we'll ask the court just to approve our proposed distribution so that there's no question. Then, of course, that would get noticed out to the beneficiaries and heirs as well, so they have a right to be heard at that type of hearing.
The question that was asked is if most wills and trusts include a no contest clause that says that if anybody contests the will or a trust, that they will be disinherited, they'll be left out. And the question is that enforceable, correct? And the answer is yes, but I mean maybe, but a stronger maybe than it used to be. So it used to be that the courts didn't like to enforce those because it basically penalizes people for exercising their constitutional right, which is to use the court system. So in recent case law, though, the courts have gone more to a reasonable or probable cause. So if you contest a will or a trust, and there is such a provision, and you're a recipient, and the court finds that your contest lacked reasonable cause, then they'll invoke the penalty. And so you do stand the risk if you're going to contest a will or a trust that you could lose whatever the bequest was. In fact, because of that, I now tell people if they wanted to disinherit somebody, it's not to disinherit them, but leave them something, because they have to have some incentive to do nothing. Because if you've already disinherited them and they're going to get nothing, then they have a stronger incentive to contest. So now, if so the kind of contests that typically are going to you'll find have no cause or no reasonable cause would be claiming that a person lacked testamentary capacity with no proof whatsoever. Those are the most common one. Well, they left me out, therefore they must have been crazy. But so it's just kind of a gray area. At what point the court's going to find that you brought this contest and you didn't have cause, or you did have good cause for it. Small estates, briefly. So where can we avoid probate if everything else has failed? We have no real estate plan. We don't want to go through probate. Where are areas that we can avoid probate? So in Arizona, if you have $75,000 of personal property of an estate or less, the people that are entitled to it can complete an affidavit and present it and claim that they're the rightful successor. This is typically used for things like a final paycheck, small insurance claims, money in the bank. Vehicles can be retitled and sold through that process. And so that's what we call the Arizona Small Estate Statute for personal property. And then for real property, if the decedent owns real property that's worth less than $100,000, after 6 months has passed, there's a process that's called an affidavit of succession to real property. And that can be filed in the county where the property is located, just like essentially like a new lawsuit. But all it is, it's filed by the person who has the right to the ownership, and the court will issue that, and then you can record it with the county recorder. And that recording really replaces the entire probate process. And that recording will title the property in the name of the successor or successors. So it's useful, for relatively small value real estate.
So many people come from states other than Arizona, and we hear oftentimes that they want to avoid probate at all costs because it's very, very expensive. And it is in a lot of states. Arizona does not have statutory fee guidelines, which is typically what drives up the cost for probate. In Arizona, the fees must be reasonable. I used the California example because I was administering a trust, and we were concerned that there was a piece of real estate in California that had been refinanced, and we didn't know if it had been put back in the trust. So we were concerned we would need a probate in California. So I reached out to an attorney there to find out what the cost would be. And for a $300,000 value real estate, it could have been an account, but it was real estate in this situation, the fee was going to be $30,000. And that was the statutory fees there in California. And many of the states that have statutory fees are set up just like that. The statutory fees typically say that on the first $75,000 of the estate, the personal representative and the attorney each are entitled to X amount, typically 7% of the value of those assets. And again, here in Arizona, we don't have that process, and it's all based on reasonableness. Typically, that is then looked at for what are the hourly rates that that attorneys in the general area charge for that type of thing. The personal representative is entitled to compensation as well. It typically will not be the same amount that the attorney would receive because they're typically not charging an hourly rate equivalent to an attorney. But it just depends on what is reasonable in that situation. The court can always be brought in to determine that if necessary. But formal probate is more costly than informal probate. As Lou mentioned earlier, informal probate is done very quickly, typically with no court-appointed appearances needed. But if we do have a formal probate, there is going to be at least one hearing, maybe additional ones. And then we really didn't talk about supervised probate. So whether informal probate is unsupervised, meaning that the court does not look at every transaction. And even formal, as Lou mentioned, might start out formal but switch to more of an informal process once the will is admitted or that type of thing. But supervised probate may occur where there is already a contesting of the estate, where there's concern about how the personal representative is handling things. And any probate can be turned into a supervised probate. Those are the ones that become very costly, even here in Arizona, because there are going to be multiple court appearances and attorney prep time and things like that. We mentioned before too, living probate can be very costly, and oftentimes I would say that it probably ends up being more costly than death probate because there is ongoing administration and reporting costs not only for the attorneys, but again, ongoing attorneys for the ward, for the guardian or conservator, as well as investigators' fees and other things over time as well. And so here's the holy grail, right? We always want to know, how do we avoid the probate process? And again, many of you, as our clients, already have plans in place that are set up to avoid the probate process, but you might have family members that don't. So trust-based estate plans will avoid probate if the trust is properly funded, okay? So if you have a trust, but you forgot to put an asset in, you forgot to tell us about the oil and gas interest you have in Oklahoma that you only receive 50 cents a year on, right? That's still an asset that belongs to the estate. There might be an easier way to collect that than a full probate there in Oklahoma, but there's still things that need to be done. So as long as your trust is properly funded, it will avoid probate. There's also things that we call probate avoidance plans. So many of our clients, we will do a will-based plan for, but we can completely avoid probate using other methods here in Arizona other than a trust. Some states that's not the case. Some states the only way to avoid probate is to use a trust-based plan. But here, we can have joint ownership with right of survivorship on various assets. So on real property, it's typically going to state that. If it is a bank account, it will typically pass to the joint owner. But that is not always appropriate in all circumstances. If it's with your spouse, that's one thing, but you typically don't want to put an adult child or someone else on your bank account with you because that becomes subject to all of their creditors if they have any in the future. We have the ability to use beneficiary deeds here in Arizona as well. And we can build into the deeds some contingencies to say what happens if your first beneficiary passes away, who would be the backup, or the contingent beneficiary to receive it. And then using payable on death or transfer on death designations and beneficiary designations as well. So those are all really the same thing, it's just the different financial institutions will refer to them differently. And there are forms that you would need to fill out with each institution to do that. And then again, making sure that your healthcare power of attorney and financial power of attorney are up to date, that they're not too old. 2 to 3 years is probably a maximum, although sometimes I would, if you're on our maintenance program, we would be more than happy to do them every year for you to give you that peace of mind so that you know that they're going to be accepted. So what Lou was saying is healthcare powers of attorney, we don't run into too many situations. And that would be very rare where someone says your healthcare power of attorney is out of date and we're not going to accept it. It's really the financial power of attorney that we run into concerns about. Like Lou was mentioning the credit union where the power of attorney is several years old, or it's a statutory based one that says, I hereby give my agent all powers under the statutes. Or if you've had a recent power of attorney in our office, they're very long and they cover everything under the sun, even including power to deal with pets, to take care of them, power to deal with digital assets, to close down your Facebook account, all of those things too. But those are all things that are becoming more important for various clients. As far as the powers of attorney go, for instance, we have a lot of snowbirds that are in our office and they have residence in another state or another area as well. We get concerned, especially maybe we've done a trust for them here in Arizona, but maybe they're going back to live full-time in another state. We would always recommend that they have the powers reviewed there. And if someone is moving here, there's one big difference that Arizona has on the healthcare side that many states don't, and that has to do with mental health care powers of attorney. We didn't really touch on that too much tonight, but the healthcare agent under a healthcare power of attorney has the ability to make almost any healthcare decision for you, including several mental health care decisions. But if you were ever in need of advanced mental health care treatment, things like placement in an inpatient behavioral health facility, in need of any sort of psychiatric care programs. Those types of things are much more stringent, and the law says that you have to give specific authority to your agent to be able to seek that type of treatment. So if somebody's moving here to Arizona, we would definitely recommend that they make sure to have a mental health care power of attorney. It could be a separate document from their existing health care doc, or it could be one and the same.
The problem is, it's again, we're dealing with a complex society. And so that credit union client of ours, if they're combing through that power of attorney, and they're not seeing very specific language that lends itself to that type of institution and the ability to withdraw funds and all, then they're going to flat reject it. And it gets more complex because most powers of attorney obviously do mention financial institutions, but we deal with other kind of issues like oil and gas and selling real estate and farming operations and ranching. So if the power of attorney doesn't cover what that person's trying to do, then they're not going to be successful. And we see a lot of powers of attorney from other states that just aren't going to be very effective here in Arizona.
So typically, especially all the documents that we do, any power of attorney in our office is going to be a durable power of attorney. But there's typically two different kinds. There's the durable power of attorney for financial purposes, and then there's the durable health care power of attorney. So all that durable means is that it's going to survive incapacity.
So what the comment is that you can take that power of attorney immediately to the institution, but in a lot of cases, you're creating a power of attorney and naming an agent, but you don't want the agent to have that power right away. You're not needing that help right away. You want that to be available when you need it so they can help you. And the problem is that that's 5 years later, that's where we deal with the passage of time, and then the institution won't take it.
We have a couple of different ways that we approach the vehicles, and one of them is that you can go down to the MDD and pay $4 and transfer the title into the trust. You don't have to change the registration, but it's just the $4 to change the title. You could go to a third-party place and change title there as well. They'll charge a little bit extra. Another option is to do a beneficiary designation form through the Motor Vehicle Division. It's a one-page form. You can name the trust, or you can name an individual beneficiary, and that document just needs to be signed and notarized, and then stapled to the original title. When it becomes a concern is if your trust has become irrevocable after you've passed away, and your hot rod beneficiary comes in and decides to drive your car across country, and they don't want to wait until it's out of the name of the trust. That's when it's a concern, because if somebody starts driving the car after the trust is irrevocable and it's in the name of the trust, if the insurance hasn't, if the insurance isn't expanding to cover that period of time, then the trust is open to liability. But during your lifetime, and the vehicles are in the name of the trust, you're still going to be personally liable even if they were in your own name. Lou and I try to make it really clear to clients that even so, sometimes they'll forget that revocable trusts don't have that creditor protection. And so a lot of times people will come and ask us, well, how do we go ahead and get that creditor protection? What if I make my trust irrevocable, right, instead of a revocable trust? Well, to do that, you have to give up control. You can't be the trustee anymore. You can't pay your own bills. You can't make the decisions on when you take a vacation. So most of the time, that isn't going to be what happens. So I always tell people to take a look at their first lines of defense. Talk to your home and auto agent. Find out, are your policy limits proper? Do you have underinsured or uninsured insurance? Do you have an umbrella policy? Is it set up properly? Those are your first lines of defense, and make sure you have a good insurance agent that's going to look into those things for you. And then we look at, maybe somebody has rental properties or business interests, and if they're not held in LLCs or other sorts of business protected entities, we can look at those and figure out if that's an appropriate action plan for the client as well. When clients are coming to us, we work with them on that funding process, and if they have a local agent or an advisor somewhere that they deal directly with, we will send a memorandum to that agent or that advisor, letting them know our recommendations for how the account should be titled or how the beneficiary designation should be set up. And the client can work directly with that advisor then to make sure all the proper forms are completed and signed and sent into the companies. Many times when clients just have an online investment company or something like that, TD Ameritrade, my husband has one of those, and I can but going on and trying to find the right forms to change title, to set up the beneficiary designations is always a little scary because we don't have somebody specific that we can talk to about it.
The second biggest problem we see is people with trusts who don't have them properly funded, either because they never did it right the first time, or they've added assets since and they haven't titled them properly. And not having your assets titled properly makes the whole plan really not work very well. It puts you into the probate scenario, which we spent the last couple of hours talking about. Trusts can be very simple, or they can be very complex depending on the size of the estate and the nature of the estate.
Okay.
A lot of it depends too on who the beneficiaries are going to be. So if it's going to be a minor child, it's really important that the assets go into the trust so we can avoid the minors and probate situation that we talked about earlier. Oftentimes it's not just the value of the estate that is an issue.
Although you can create trust for beneficiaries in a will. So your will could say, I leave, all my estate, and then the beneficiary, instead of receiving it outright, could receive it in a trust. That's called the testamentary trust. It isn't created until death, and it's created in the will. We don't think it's the most efficient way to do it, but it's done.
We appreciate everybody coming tonight, and thank you for your participation at all of our workshops.